The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon, everyone. The next case is Z.M.T, and we'll hear from the appellant.
Good afternoon. May it please the court. I'm Mary McCullers-Reese for the respondent appellant mother, Precious Barnes. I'd like to reserve 5 minutes for rebuttal. This case is about how our court should proceed when the record raises serious questions about the efficacy of counsel in a termination of parental rights action, particularly where those questions pertain to notice. When parental rights are at stake, parents are entitled to representation by counsel. Effective representation by counsel is one of the essential procedures put in place to ensure the fundamental fairness of proceedings to TPR. In the present case, the record raises 2 questions about 2 aspects of counsel's performance. First, whether she made sure that her client knew about the hearing, and second, why she didn't advocate for Ms. Barnes. On this record, a holding that Ms. Barnes received effective assistance of counsel would be a significant erosion of the fundamental procedures intended to guarantee fair hearings for parents. Because the record here leaves unanswered questions about the fairness of the proceedings, we respectfully request that this court vacate the order terminating parental rights and remand for additional findings by the trial court. Because of the posture of this case, counsel was the only way that Ms. Barnes would have known about this termination of parental rights action. This action began when DSS filed a petition alleging that Ms. Barnes' baby was neglected. Trial court appointed counsel for her, and Ms. Barnes appeared at the non-secure custody hearing, the adjudication hearing, the disposition hearing, and in January 2020, a permanency planning hearing. She made efforts toward her case plan, including taking parenting classes and submitting to a substance abuse evaluation. But in March 2020, DSS filed a motion to terminate her parental rights. Rather than serving Ms. Barnes, notice of that motion was served on counsel by mail in care of counsel. There's no calendaring notice in the record setting the termination of parental rights for hearing. The TPR came on for hearing on June 10th, and Ms. Barnes wasn't present. Counsel didn't file an answer, and she didn't participate in the hearing. The first of the 2 areas of concern arising from the poor performance of counsel is whether counsel made sure that Ms. Barnes knew that her parental rights might be terminated. It's significant.
Ms. Reese, before we go any further, I want to ask you an analytical question about how we ought to view this case, if you don't mind. In your brief, at least in your argument so far, you've couched this as an ineffective assistance claim. Typically, as you know probably better than I do, an ineffective assistance claim requires both a showing of deficient performance and also a showing of prejudice. Obviously, under our case law, you can look at prejudice without looking at deficient performance if you need to. To what extent are you obligated to make a showing of prejudice in this instance?
You blipped out right at the end, but I believe you asked to what extent would I need to make a showing of prejudice in a case like this?
That's right.
In this case, the representation of counsel was so tied up with the notice and communication that Ms. Barnes received that her parental rights were even at stake, and the notice that she received to appear, that this went beyond any kind of strategic decision or trial tactics by counsel, but went to the very most fundamental nature of Ms. Barnes knowing that she needed to be present at all and knowing that her rights might be terminated. The only way she would have had notice was by counsel providing it to her. So in this case, the prejudice.
And I understand that, but it seems to me that maybe I'm wrong, but it seems to me that may go more to deficient performance than prejudice. Typically, prejudice requires some showing that there's a reasonable probability that the outcome would have been different had counsel's performance not been deficient. How do you make that showing in this case?
In this case, she didn't. It's not clear that she even knew that she needed to be there. How one would go, this court has considered prejudice, has considered ineffective assistance in several cases, but has not really considered how notice ties in with that. This court has held that in IAC cases involving strategy or trial tactics, a showing of prejudice must be made by the parents. And in those cases has evaluated, say, did someone make a hearsay objection or something along those lines. But in this case, those holdings haven't really encompassed cases where the parent may not have even known to be present. And I'd say there's inherent prejudice in not knowing that there's an action pending to terminate your parental rights.
Are you asking us to adopt some sort of prejudice per se standard in notice related cases?
I think that in this, that as you look at SNW, ARC, CDH, those cases, the Court of Appeals found the questions about notice and communication to be so concerning that they remanded for inquiry into the effectiveness of counsel, because they, in fact, the notice went to the very fairness of the hearing, and it's prejudicial not to have received notice.
All right. Thank you very much.
Well, are we to presume by way of a legal presumption that if there is not notice on the record that counsel gives concerning notification of a parent, that notice was not received?
I don't know that you can presume it. I think in this case, you had a very specific set of circumstances. Counsel basically, I would say, is almost like counsel serves as an inbox for service of this motion to terminate parental rights, which greatly ups the ante as far as what's at stake here. From that point on, we're talking about an entirely different set of consequences to the action, where counsel says at the motion to continue, in a sort of cursory motion to continue, counsel says, well, I sent her motion. I sent her notice. And the trial court doesn't inquire at all beyond that. What you have, we don't know that Ms. Barnes received notice. There's no indication that she got notice, and that's a very different thing. So I think this is sufficient for this court to have questions, as they did in S&W, to remand back down to the trial court to determine, where did that notice get sent? Was it received?
Well, I don't want to necessarily mix and match statutes, but according to Rule 4 under the statutes, if notice is sent, or if there is some demonstration at least that there is some attempt to send notice, which apparently there was on behalf of the parents' counsel, the mother's counsel, is that it's presumed that notice is received if it was not returned. Does that count at all, or are you saying that lack of notice on the record itself is an indication of ineffective assistance of counsel because it's not on the record?
Well, and it's not on the record. I'd say, there's no indication from counsel that she got notice. There's indication she sent it notice. And I'll say there are 4 different addresses from Ms. Barnes contained in this file. Counsel says she sent the notice to Ms. Barnes, but we don't know that she got it, or how she would have received it, or even how it was sent. So in this circumstances, am I answering your question?
Yes, please continue. Oh, well, if you were finished, I was going to extend it a bit, pursuant to what Justice Irvin had asked you. So are you asking us then to extend ineffective assistance of counsel to a point now where there is not on the record proof given of some affirmative nature that a parent has received notice from the counsel in the absence of the parent from a hearing, that therefore is subject to ineffective assistance of counsel without a demonstration that there would have been otherwise the probability of another outcome? Yes,
Your Honor. I would say in this case that the prejudice is inherent to the questions about notice. Notice is so basic to a fair hearing that how would a parent who hasn't had notice or even known that their parental rights are at stake, how would they possibly go about demonstrating the prejudice of not having counsel effectively get that notice to them? So yes.
So lack of notice on the record then would not be considered to be something neutral, but it is to be considered by this court, in your view, as to lead towards, you don't want to call it a presumption, perhaps an inference, but in some way that is to count against the counsel's effective assistance.
Right. Counsel was entirely tasked, because of the way the statute is in this case, counsel's entirely responsible. There's no other way that she was going to receive notice. And that's particularly true. I think there's nothing in the record indicating that prior to the filing of the TPR action, notices of, say, the permanency planning hearing and notices like that were directed to at least some address associated directly with Ms. Barnes. Once the termination motion is filed, those notices don't go to Ms. Barnes anymore. There's nothing telling her that this was actually going to come on June 10th. So it was entirely wrapped up in the duties of counsel.
Thank you.
So going back to the basic.
Let me ask you this. The juvenile permanency planning order entered on January the 23rd indicates that the birth mother was present at that time. And it also indicates that there's, I guess, ongoing questions with regard to what that will be. I'm looking to see if they made the plan a concurrent plan with adoption reunification. Does the fact that the biological mother knew that the trial court was considering adoption as a plan, does that impact the analysis at all?
Well, Your Honor, I think that in this case, reunification remained the primary permanency plan in this matter first. So certainly, I mean, once the matter was adjudicated, there was always the possibility that it is going to move into a higher level. But I don't think that's the same as having a direct notice that someone has filed a new civil proceeding, essentially, which is a carry on from the prior one, but one that greatly ups your ante. And Your Honor mentioned too the permanency planning hearing. Ms. Barnes was present at that permanency planning hearing, which then set the matter for June 10th. And there's a lot of confusion in the record after that, because her counsel gets served in March with the termination of parental rights action. And then the matter, for some reason, comes back on in April and again in May for the permanency planning hearing that was already set in June. By that time, there are already COVID shutdowns happening in the whole courthouse, and the matter gets continued twice and comes back on, we presume, we don't know, but we presume, for a permanency planning hearing on June 10th. That notice, I think, was confusing at best and was certainly not notice on the level of your rights might be terminated, you might lose your child permanently on June 10th. Intertwined with these issues is the fact that Ms. Barnes' counsel didn't file a response to the motion to terminate parental rights. NCGS 7B1107 provides that upon the failure of a respondent parent to file written response to the motion within 30 days after service, the court may issue an order terminating parental rights, provided the court shall order a hearing on the motion and may examine the movement or others in regards to the allegations. The GAL argues that because counsel didn't file an answer to the motion for TPR, she waived a fuller hearing for Ms. Barnes, including subsequent inquiry into the effectiveness of counsel. I think of this as a catch-22 argument where relief from ineffective assistance of counsel would be prohibited by counsel's own failure to file an answer, because preparing, signing, filing an answer are acts that require counsel's participation and expertise. The argument essentially is that we can't argue ineffective assistance of counsel is ineffective because counsel was ineffective. If anything, counsel's failure to file an answer is one more subject for inquiry in considering their effectiveness. As to the contention more broadly that the legislature must have intended some difference between a hearing where counsel files an answer on the parent's behalf and a hearing where counsel doesn't, GS 70-1108 provides a more succinct statement of a tangible difference. If an answer or response denies a material allegation of the petition or motion, the court shall appoint a GAL for the juvenile to represent the best interests of the child. Statute goes on to say that if no respondent denies material allegations, the court may, in its discretion, appoint a juvenile for the child. This, in conjunction with the legislature's amendment of the statute away from the mandatory shall language that was considered in Tyner, suggests an intention to move away from rather than towards a more summary or default type hearing. The guardian ad litem's argument in this case would mean that counsel, after basically having served as a receipt place for DSS to achieve service of the termination action, could waive the parent's right to the full hearing mandated by GS 7B1109 without any showing that the parent actually received notice of the action. The language of the statutes just doesn't really indicate that the legislature intended that. At the motion to continue, just prior to the pretrial conference, counsel advised the court that she had sent Ms. Barnes notice of the hearing. It's true. And a more than cursory inquiry by the trial court into exactly what that meant during the pretrial hearing would have been entirely within the scope of GS 7B1108.1, which provides that the trial court shall consider whether all summons, service of process, and notice requirements have been met. And given the time frame, which was just after courthouses started shutting down for COVID, that inquiry would have been a reasonable one. It's important to remember that Ms. Barnes appeared for every substantive hearing except for this one. In fact, the trial court found in the adjudication order that Ms. Barnes was present for the hearing, but later amended that finding in a handwritten note on the disposition order. And when Ms. Barnes learned that her rights had been terminated in her absence, she went to counsel's office and signed a notice of appeal. And counsel filed the notice of appeal late. But for this court's granting petition for cert, Ms. Barnes would have also lost her right to review in this court. Parents have a fundamental right to counsel in proceedings intended to result in the termination of parental rights. And they have the right to expect certain things of counsel. They should be able to expect that counsel will advise them of significant developments in their case, including the filing of a termination of parental rights action in a what was previously an A&D action filed by DSS. They should be able to expect the counsel will advise them of the need to answer pleadings and file those pleadings on their behalf. And they should be able to expect that counsel will provide them with notice of important hearing dates, especially where counsel receives those notices on behalf of the parent. And they should have the right to expect that even where allegations against them are daunting, counsel will make some effort to defend them. And it's not clear in this case that any of that happened. For these reasons, if there are no questions from the court at this point.
I do have one question.
Yeah.
You may have touched on this just at the end, but you've really focused on the notice issue. But I'm curious what significance you think we should draw from counsel's what her attorney did in both in sort of pursuing the continuance motion and then everything that happened after that at the hearing. Like, what is the significance of counsel's actions there?
Well, in this case, Your Honor, it's almost like she didn't have counsel. It is almost to the extent of not having been appointed counsel for this new action. Counsel receives this motion, check, served, and client's deemed served. Then we have no real indication other than this one cursory statement during the continuance motion saying, I sent her notice. We don't know where, and we don't know whether she received it. And then after that, it is absolutely nothing during the hearing. And on top of that, had not filed an answer, even just a most basic answer denying the allegations. So it compounds the notice, and it sort of stands behind the problems that we suspect may have happened with notice.
Counsel, before you finish, I do want to make sure I'm appreciating the potential precedential value of what I think I'm hearing you argue. Are you saying that in a situation such as this one, where there is nothing on the record as to notice being actually received by the absent parent, that you are arguing that there should be a de facto finding that the parent did not receive notice, therefore there is some inference or presumption that the parent's counsel did not render effective assistance of counsel. And if all that I have said is what you are representing, is there any other area of the law where prejudice need not be shown, which would include whether or not there is the likelihood of another result if there had been effective assistance of counsel?
Your Honor, I think the procedural posture of a TPR is so unique, especially when and yes, what you said, I believe, is a correct statement of what we're stating. But to go on from that, a TPR filed by motion is in such a unique posture in the law where the ante has been so greatly upped by the filing of a motion in the cause that is not even served necessarily on the parent, that yes, where the record doesn't indicate that the parent has had notice in some way, or that there is some inference that would be on counsel.
So you consider this to be such a monumental potential determination by a trial court that it's a standalone situation aside from any other areas in which prejudice must be shown to show otherwise that a different result may likely have occurred?
Yes, Your Honor. I think potentially not having notice, and of course, we've asked that this be remanded to the trial court to determine whether that is the case. But if that were the case, a parent who did not even have notice that the new TPR was pending, that's inherently prejudicial.
All right, thank you.
There are no other questions? I'll stand down.
Thank you. We'll hear from the appellee.
Good afternoon, Chief Justice Newby and Associate Justices. May it please the court. I hope you can hear me okay. I'm starting to make sure I project. I'm Tom Griffin. I'm with Parker Poe. I'm honored to be here on behalf of the North Carolina Guardian Ad Litem Appellate Program and on behalf of the minor child. I'm here today with Mr. Audino, Jay Audino, who is here representing the Beaufort County Department of Social Services, and we will do our best to split our time equally. I want to start off with how I see the appellant's case, which is I'm not exactly sure that I received ineffective assistance of counsel. I think this is a fair reading of the briefing. I'm not sure, so I think we should send it back to help me figure out if I got ineffective assistance of counsel. Let's have the inquiry first. And if we follow that, it seems like a pretty simple request, but it actually drags a big suitcase into this court and asks us to unpack a lot of issues. The trial court's proper role, the boundaries of inquiry into counsel's conduct, who should conduct the inquiry, a parent's responsibilities, the latitude that this court provides trial counsel in strategy and tactics. Should we be asking our trial court to monitor counsel conduct on the fly? All sorts of things. I'm probably missing several. But our view, going to where Justice Irvin started his questioning, is that this case is relatively straightforward. It is a case for which this court has already established a framework. It is a case about burdens. It's a case of what are the burdens, who has the burdens, who should have a burden, how do you frame that burden, and has the burden been met? And at the end of the day, I think this case is even more simple, because I think when you go at that last question, that has the appellant shown any prejudice at all from the conduct that she's complaining about in this case? Has she established a reasonable likelihood that but for what happened or didn't happen at this hearing, the hearing would have turned out differently? She hasn't done that, and she hasn't tried. Other than
to talk somewhat out of the other side of my mouth now.
Yes, sir.
One of the things that has concerned me about ineffective assistance claims in this context has been, how does someone make a showing? I mean, what type of showing would suffice to show prejudice in the case in which the allegation is that my attorney didn't effectively advocate for me because the attorney didn't do anything. I mean, in the criminal context, we've got a situation where you can file a post-conviction motion and you have some opportunity to bring forward evidence that might have been presented in the event that representation had been up to par. That doesn't exist here. So what type of how do you go about making a showing of prejudice in contexts like this one?
Justice Irvin, let me start off with, and I'm going to answer your question in two parts.
Okay.
The first is, what's the framework for deciding prejudice? And the Supreme Court in Strickland v. Washington said, and I'm going to read now, the governing legal standard plays a critical role in defining the question to be asked in assessing the prejudice from counsel's errors. So it had a couple examples of, in a criminal case, but for the errors, might the fact finder have not found reasonable doubt? In a sentencing case, but for the errors, might they have balanced mitigating factors differently? And in this case, it's a section, and that's why we started with section 1107. Under a hearing that's contemplated by section 1107, has the appellant shown anything that would suggest that the outcome of that hearing would be reasonably likely to be different? And so I think it would be incumbent, and well, then Strickland goes on to say, let's take a look at the facts that are unaffected by error, and then the facts that might be, and balance those and see whether it'd be a reasonable likelihood of a different outcome. And in this case, the appellant doesn't help us answer that question because she hasn't tried at all. I think it would be incumbent upon the appellant to say, if I had been there, I might have testified to this. I would have testified to this, or this is where the record is confusing, or this is where the record doesn't line up. The evidentiary record doesn't line up with the testimonial record. I mean, anything. Like, tell me how the case would have ended up differently. In all of the cases, including cases that I'm aware of, where counsel sat silent, like the M.Z.M. case in the juvenile code context or State v. Taylor during a sentencing context, has required some showing of prejudice. And so I think it would be incumbent upon appellant, in this case, to have some showing of prejudice. Now, it's difficult here because there's been no allegation or no argument that any of the findings are not supported by the record. And so the way we treat those is that the findings are deemed conclusive. And so I'm not sure exactly what the appellant would argue, but she hasn't tried. And I think you have to give it a shot.
If you look at the cases upon which your colleague, Ms. Reese, relies, all of them contain language that basically says we don't know what could have been shown because no advocacy was done, and therefore we will remand this case for further proceedings. Why is that approach, in your view, not appropriate?
Well, I think that, and this may not make sense, Your Honor, but this is how I think that there's the record and there's the record. Right. So what I'm talking about is a robust record on the substance of the case, on the grounds of the case, on establishing grounds for termination of parental rights. What Ms. Reese was talking about is the record of communication between the client and her counsel. Right. And so in the cases where she is putting before the court, SNW, ARC, she filed a memorandum of CDH. In each of those cases, the record demonstrates or causes serious questions about the client's contact with the parent's contact with their counsel. In SNW, I think this is correct. The counsel had never spoken with the parent and had put 1.1 hours into the case. In ARC, there was a serious evidence of mental incapacity and questions about whether the parent had received notice at all. In CDH, what we have is a parent who didn't show up for hearings. I think she showed up for the first non-secure custody hearing, and then that was it. So each of those records says, I'm not able to infer, the appellate court, not able to infer from this record that there was communication. In this case, we have the counsel saying during the hearing, I sent notice to my client. I think we have to take her at her word. She sent notice to the client. And then I think you can infer from the robust record here where counsel showed up with her client at numerous hearings, including the permanency planning hearing, which considered similar issues to the hearing. If you look at the findings of the permanency planning order, excuse me, with the TPR findings, they're very similar. The same issues were raised. And so this record allows an inference of proper communication between counsel and her lawyer. I don't think we want to be in a situation where we are questioning a counsel about the intimate details of communication with their client. I mean, there may be a reason why Ms. Jones, in this case, kept her discussion of the conversations with her client to a minimum. There may be reasons why she didn't advocate for it, and this court allows latitude for trial counsel to do that. And so I think, I don't know if that answers your question, Your Honor, but this record is different. It's robust on both the communication and on the substance of the contact. And I also think that if we think about the record in the context of 1107, here's why I think 1107 is a fair.
Before you go there, just I'm looking at the pretrial TPR order, finding of fact number 4. The trial court found respondent mother is represented by names of attorney, and she has been served with the motion to terminate her parental rights. Is that being contested?
Not that I not to put the words in Ms. Reese's mouth, but she apparently is saying that we can't know for a fact.
But we do have a finding of fact by the trial court, and my question is that precise finding of fact being contested?
Not that I'm aware of, no, except by implication, to be fair. But it is not being directly contested. I point out that the pretrial order in our briefing. Now, here's why I think it's important to focus on 1107 as a framework. And I will note that 1107 doesn't require the parent to be present or to be questioned. I think that's vitally important. Now, Ms. Reese points out 1108. When it's true, 1108 is both permissive and sets out something that a consequence if somebody denies material fact. The respondents in 1108 is a broader population than the parent respondent. 1107 applies to the parent respondent. It sets out a consequence if the parent respondent doesn't file an answer. Right? And so here's how I think about it in plain English. And this is why I think this is a fair interpretation of the statute. The code turns to the parent and asks a pretty simple question. Do you want to participate? And if you want to participate, well, back up. We're going to protect your rights either way. We're going to ensure a constitutionally appropriate procedure. But you need to let us know if you want to participate. And if you do, we'll have a full hearing under 1109. And if you don't, we're going to fall under 1107. That's the framework that Strickland tells us to look at. But we're still going to protect your rights. We're going to hold a hearing. We're going to take a look at the allegations in the motion in this case. We're going to take evidence that allows us to determine whether those allegations are established by clear, cogent, and convincing evidence. And then we'll determine whether we're going to terminate your rights or not. You've opted out, but we're still going to do that.
Can I just follow up on the finding of fact number 4 and the trial court's finding that the mother was served with notice of the motion? Is there any evidence in the record other than the statement of Ms. Jones when she makes the motion for continuance, which I believe is on page 4 of the transcript, where she says, I have sent notice of this hearing to my client as well? Is there other evidence in the record that the mother received notice of this hearing and notice of the motion to terminate her parental rights?
Not that I'm aware of. Justice Earls.
So if I understand your argument correctly, you're saying that to satisfy due process, a parent, if an attorney sends up and says, I have sent notice of this hearing, nothing more, nothing, I sent it to 4 addresses, I sent it to this address, which is the most recent one, I sent it and she called me back, so I know she got it. All the attorney says is, I have sent notice of this hearing to my client as well. That is enough to guarantee due process and to allow the court to conclude that the parent has been served.
In my view, there's a multi-part answer to that, Justice Earls. One is, yes, I think that's a very important starting point. I think we take counsel at her word. I sent the notice. Two, you take a look at the record, and does the record support an inference that there's a communicative, robust relationship between counsel and her client? And the record in this case is communicative and robust. And if we're talking about due process, I think that a parent would need to show, this hasn't been briefed directly, Your Honor, there are a couple cases in my brief that refer to this, that you would need to follow the, I believe it's the Matthew Eldridge case for due process for somebody being present or not in a hearing. And what that in essence boils down to is you need to show prejudice, that your absence at a hearing, in order to implicate due process concerns, you need to establish prejudice. And in this case, you need to establish that it was reasonably likely that this would have turned out differently than it did. And I think that means that the parent has to come forward and say, this is what would have happened in a non-speculative way. There are cases that I've cited in my briefs that talk about parents who were not present, but they were unable to describe prejudice, and their claims were not permitted to go forward. Ineffective assistance of counsel claims were not permitted to go forward. And so yes, that's the only notice that I'm aware of actual in the record, but I think there are other things in the record that help support the relationship. And I think that the law directs us back to prejudice. The law overall, writ large, is very, very cautious about getting in between the trial court's administration of justice and what's going on in a counsel's mind. And before we allow intrusion into that, we have a series of requests and framework. And the primary request is, tell me why it matters. Make it a difference to get in between, to tell a trial court, now you have to stop after each motion and see if this counsel was effective in her hearsay motion or in her examination or lack of examination. Before we get into those things, let's talk about prejudice.
But aren't you putting the cart before the horse? Because, or I'm curious how you respond to the kind of catch-22 argument, because if the mother, certainly the mother couldn't have made that showing at this hearing, because you'd have to, she wasn't there, right?
Yes. And so the catch-22, that is an interesting argument. And I actually cocked my head a little bit when I read that, because I think it's a fair question about, what is it about counsel's conduct that then insulates her from inquiry? We're not saying it insulates her from inquiry, by the way. Just knock that one out of the park. We're not saying that if you fail to file answer, there is no more inquiry into your actions. What we're saying is, if the parent is upset about that, the parent has to allege properly ineffective assistance of counsel. I'm actually not sure, based on the briefing here, that's really been raised, the failure to answer as ineffective assistance of counsel, the request her to deal with what happened at the hearing. But nevertheless, let's assume that it was. You have to show prejudice. So let's think of this in the how this statute would work in the future, right? Let's put aside the appellant's claims. You fail to answer, we go into 11.0. We go into 11.07. I think that the consequence of a decision by this court that 11.07 means something will have a judicial positive effect. I can't get my words around that, in the sense that we will now have, parents and their counsel will now understand this matters. You need to join the issue before the court. You need to admit or deny. And I think that'll have a beneficial impact on narrowing the issues for trial courts to consider, and will cause maybe a better relationship between counsel and their parents, because they have to think about it.
Mr. Griffin, you would concede that your differentiation between 11.07 hearings and other types of hearings in which answers have been filed is not an approach that's been taken in the case law to this point?
Yes, there are a couple of court of appeals decisions that nip around the edges.
Well, both of them basically say there's no default type proceeding in a termination case, right?
That's correct. Tyner says no default, but there is there in my briefing, there's a case that says, I think this is DW Jr., that says a trial court may limit testimony can limit a parent's case in chief to only those allegations in the motion. Not quite the exact same issue, but it understands that 11.07 has consequences.
That to me sounds as if we limit the scope of the case to the pleading filed by the party with the burden of proof, which
That's
seems
correct.
to me to be a different kind of a question than what statute we're proceeding under. Why at this point, given that I mean, I haven't got Curtis in front of me, but Tanner was decided in 1992. Why at this point should we go off in a different direction with 1107 when the General Assembly has not taken any action to overturn the decisions that the Court of Appeals made, that at least to me seem to be inconsistent with the approach that you're advocating?
I'm not sure they're directly inconsistent, Your Honor, because what Tyner says is there can't be a default proceeding. Like, you need to go on to a hearing. Now, I think it's, for the reasons stated in my brief, I think basic principles of statutory construction mean that 1107 and 1109 have to be different things. They have to be, otherwise we can't read 1107 out of the statute. So what is that? So what 1107 says is we can't have a default hearing, like a default proceeding, straight up default, but we can have a proceeding that is designed to streamline the process because the parent has chosen not to participate, has to streamline the process and then apply the correct burden of proof and find that the grounds are supported by the correct burden of proof. We meet the Santosky versus Kramer admonition, and that is an appropriate way to streamline it. And I think that if we interpret the statute as we have suggested, if you interpret the statute as we have suggested, it will streamline judicial proceedings. And for those cases where a parent is upset, she can bring an ineffective assistance of counsel claim. And if she can establish prejudice, meet her burden of prejudice, then she can prevail before we go and inquire. But as this
what procedural mechanism exists for a parent in that set of circumstances to bring an ineffective assistance of counsel claim?
I think you bring it on appeal, just like in an ordinary case. You bring it in, but you take the record before you and you demonstrate to this court whether it is reasonably likely that this case would have turned out differently if she had been there or for counsel answered any questions. And we don't need to work around the nuances of that in this case, Justice Ervin, because there's been no shot at it. There's been no showing whatsoever. And I think it'd be an interesting precedent to set that we're not going to require a showing of prejudice for this kind of activity. And that's what this case is about. It's about how can we posit this case to the court to allow the appellant to avoid the necessity of showing prejudice, either from the continuance or her lack of presence or the denial of the continuance of the IAC claim. I think she should be forced to show some prejudice, show any. She hasn't. The case should not be remanded and the trial court order should be affirmed. I see that I've now cut way into Mr. Audino's time. If there are no further questions, I will pass the baton.
All right. Thank you, Tom, and good afternoon, Chief Justice, Associate Justices. I know Tom has already introduced me, but I am Jay Audino, and I'm here representing the Beaufort County Department of Social Services. Now, with the time I have left, I think I'll try to wrap this up in a nice, neat bow as best I can. The main issue before this court that is raised by the appellant respondent mother is whether we have ineffective assistance, and really, does this court need to remand it for the trial court to make a further inquiry, an inquiry that goes to the two-pronged test that your honors are all aware of in this situation, which this court would have to find, or to determine ineffective assistance, you have to find that counsel's performance is deficient or fell below an objective standard of reasonableness, and the performance is so deficient that respondent parent was denied a fair hearing. And what is being asked here by the respondent mother is that based on the record, your honors cannot determine that, and it has to be sent back down. It has to be remanded. What we would ask your honors to determine is that is not the case. It does not have to be remanded. It does not have to be sent down. The record is sufficient to show that ineffective assistance of counsel cannot be proven here. We get to the issue which Tom raised is, where can we find any prejudice? And can we find any prejudice? Your honors, we say that you cannot, that no one could in this situation. And the reason for that is based on the record that is before this court, a record that the respondent mother was worse off at the time of the TPR trial than she was nearly a year prior when the initial underlying petition was filed. By respondent mother's own admissions in the record, which was made part of previous court orders and which was testified to in the TPR trial by the social worker, respondent mother increased her heroin usage. Respondent mother failed to go to individual therapy, which she'd been ordered to do. Respondent mother had failed to get substance abuse counseling. And really concerning here is that while respondent mother early in the case seemed to be visiting with the child, at least the 3 months leading up to the TPR trial, respondent mother never visited with the child. So she is worse off. And I failed to even mention that she was charged in January and February of 2020, charged with very serious drug-related crimes, violent crimes, all of which happened 6 months after the petition is filed and leading up to the time of the TPR. Now, I understand we have this question here of, well, isn't the fact that respondent mother's appointed attorney didn't say more about her effort to provide notice, isn't that enough to show a prejudice that has to go back? Well, I would certainly hope your justices, the justices find that no, that's not the case. For one, and certainly this is different than the cases that respondent mother cited in her brief. It is different than SNW. It is different than ARC, which are the two cases that are cited in respondent mother's brief. As Tom said, those are cases where the respondent in that case had next to no contact with their counsel. One of those two respondent parents had mental health issues and had a Rule 17 guardian appointed to them. This case is very different. It's different in that from day one, in June of 2019, respondent mother was given Jacinta Jones as her appointed attorney. And she met Jacinta Jones about a week after that when they had the first non-secured hearing. She was back in court with Ms. Jones in July of 2019 for the adjudication hearing. She was in court in August with Ms. Jones for the disposition hearing. She was in court with Ms. Jones in January of 2020 for the permanency planning hearing. Now, one thing I do want to say about that procedural progression, and where I'd like to say something a little different than what Ms. Reese said earlier, is that there were two hearings that respondent mother did not show up to. The first scheduled permanency planning hearing was not in January of 2020. The first permanency planning hearing was actually a few months earlier. That is in the record. It shows a continuance order, which cites the respondent mother did not show up to that first permanency planning hearing. And it continued it a month later, I believe, to December. That continuance order from the December hearing shows respondent mother did not show up to the hearing. And then it was continued to January, at which time respondent mother did show up and was made aware at that hearing when she was there by the court's own sharing of information that there would be a hearing, a permanency planning hearing in June of 2021. Now,
but just to address those continuance orders, the first one simply says that the parties requested the continuance. The second one says that the Department of Social Services requested and needed the continuance. So on the face of them, those orders don't suggest that it was solely on motion of the mother that those were continued.
I'm sorry, Justice Earls, and if I implied that they were continuances based on the mother's request, I'm sorry. That was not the case. That's not what I was trying to say. I was just saying there were two hearings where respondent mother was not there, to say that the termination trial in June was not the first time that mom missed a hearing. Now, we go to this question of, did Ms. Jones do enough in the June hearing to satisfy this court that no further inquiry needs to be made? Well, at the call of the matter, Ms. Jones said, Judge, and I believe it was actually following up to the attorney who was representing respondent father, Ms. Jones says, Judge, I'm going to ask for a continuance as well. I have provided notice to my client, and I believe Ms. Jones also stated that my client is typically here for hearings. So she advocated for her client in that sense. Now, the concern that I have, which I raised in my brief, is how far does this inquiry go? How much do we expect trial counsel to say? what if we're in a situation where Ms. Jones has knowledge and has information, but none of that would help her client get a continuance, and it would only hurt it? We know that respondent mother was arrested multiple times earlier this year. What if respondent mother, and we don't know this in the record, I'm not suggesting she was, but what if respondent mother was just arrested a few days prior and only Ms. Jones knows? Certainly she's not going to want to get an inquiry from the court as to what do you know for sure about where mom is at, because she doesn't want to disclose that to the court, and she doesn't necessarily have to in that situation. We also run into a big question, and this goes to Justice Morgan's inquiry about, look, how much proof does an attorney need to give to show that notice has been given to their client? I'm now concerned that based on if we find some prejudice per se, if an attorney can't prove they have served their own client, that now attorneys can't just mail things to their clients. We're going to have to do everything by certified mail to get that green card back and prove to the court that we even send a notice to our clients. Certainly that's not required, and we have case law that shows that's not required. We have a strong presumption that counsel's conduct falls within a range of reasonable professional assistance. What's being asked here by the respondent mother is that this court should just assume that because she didn't say anything more than I provided notice, she has somehow not done her job. Well, isn't that what's required of us, is to serve notice on our client, to provide it to our client? We also get to this question of, well, was her silence during the hearing, does that somehow show prejudice per se, or does it need to be remanded for the court to make a further inquiry? Well, justices, I'll tell you, I'm concerned about a situation where the trial court is getting this sent back and inquiring Ms. Jones about, why did you not question witnesses? Why did you not make a closing argument? What was your plan about this trial, and why did you not speak? Now, we already have case law that says an attorney does not have to raise anything during a hearing, and in this situation, maybe she couldn't. When the facts are completely against the respondent mother, when the respondent mother has put herself in a worse situation at the time of the trial than she did as the petition was done, what could Ms. Jones say? So we would ask your honors find that this should be affirmed and not ineffective assistance.
Thank you, counsel. Rebuttal.
Your honors, it's nearly impossible. Prejudice comes up over and over again in this one, and it's nearly impossible I would contend, for a parent to show prejudice when the parent possibly doesn't even know that there has been this action to terminate their parental rights. And counsel has left them essentially unrepresented in court on those same proceedings. The prejudice in this matter, if she hasn't received notice, is inherent in a complete lack of notice. I want to, Justice Newby and Justice Earls talked about finding number 4, that trial counsel has been served. In this context, though, we have alleged ineffective assistance of counsel. Trial counsel was got tagged with a service. That doesn't mean that Ms. Barnes received notice. That's an entirely different situation. And in this case, where there was absolutely no inquiry and no development as to how that would have happened, the record's really unclear about it. If the trial court had asked those questions, then we might have more information, but we don't.
Let me ask just a quick question about that. On this record, as I understand it, what we have is the attorney representing to the court that she sent the notice to the client, the mother, and then that the mother wasn't at the hearing. And yeah, that's all we have. Is that right?
That is all we have. She says,
since the only affirmative evidence that we have in the record is that the attorney says she notified the client, what basis do we have for finding otherwise, or for even looking beyond that?
In the record, and I'm sort of channeling SNW and ARC, where basically the record gave rise to questions about how this whole situation went down. The attorney says in the most, I sent her notice. It doesn't say she received the notice. It doesn't say I sent it to this address that is associated with my client. and it doesn't say my client responded to me when she received it. And 9 times out of 10, we probably, that someone has been served through their counsel and the issue doesn't arise. In this case, the record gives rise to questions about the efficacy and communications between counsel. And I want to dispute the contention that there is a robust record of communication between client and counsel in this matter. What we know, what the record does show, is a robust effort on Ms. Barnes' part to show up for hearings. She showed up in court when matters were calendared until she didn't after the TPR motion was filed. So I would say the record really isn't robust and doesn't provide us information about what kind of communications there were.
Well, unless we can infer from her not being at the hearing that she didn't know about it, which seems maybe like a step too far, then I think what we're being asked to do is to go behind counsel's assertion. And I don't know of any authority for doing that unless there's some indication, like a letter or an email from her saying, I didn't know about the hearing, something to indicate that she didn't know about it.
And that's,
I don't think, you don't want us to sort of second guess counsel's assertions to the court, do you?
generally speaking, no. And it's not every case that is coming to this court on ineffective assistance of counsel. In this case, the record does give rise to questions about the effectiveness of counsel, and we are asking in this case that the court question behind that.
And is that because during the hearing there wasn't much of a defense, or, well, I guess
There was none. Yeah.
I mean, put to me, Ms. Reese, put to me as succinctly as you can the answer to this question. What is it in the facts of this record that would tend to suggest that counsel may not have notified your client?
Yes, Your Honor. You have a client who shows up for every substantive hearing. And I hear what Mr. Audino is saying about this. There was a hearing to place the child in a foster care or mood placement or something like that. But really for the essential hearings, she showed up. Then you have the matter moving to termination of parental rights. That's served on counsel. After that, there is Ms. Barnes misses the single most important hearing that has come down the pipe thus far. Counsel can't state, it doesn't state exactly how she has been served, and the court doesn't inquire beyond it. In addition, counsel didn't even file an answer on Ms. Barnes' behalf, and in this case, I can't really think of a strategic reason for not having done that. And it suggests, I certainly don't know exactly what communications occurred between Ms. Barnes and her counsel because it isn't in the record, but it certainly suggests that there was a breakdown of communication, that they weren't talking to each other about this. I can't imagine why counsel.
Basically, your argument is that we should infer a lack of notice from the fact that certain things were not done.
Yes, in this case, it's very unclear why she wouldn't have showed up, and counsel has sort of left the helm unattended.
To what extent should the fact that there may be alternative explanations for why all these things happened, what effect should that have on our view of the case?
I would say, Your Honor, that there is certainly enough here to raise enough questions as the Court of Appeals, was considering an SNW and that line of cases. At some point, the record raises enough questions to cause us to remand it or to want it to be remanded back down to the trial court, who does have easy answers, who can seek answers to these questions. And the trial court can make findings as to exactly what the relationship was, but we just don't know, and the record doesn't look good procedurally. It does not appear that there was a lot of conversation between counsel and client.
Is the burden upon you to present evidence that would tend to support a finding of lack of notice?
I'm sorry?
I said, do you have an obligation to at least come forward with some evidence or some information that would tend to suggest a lack of notice in order for such a hearing to be appropriate?
I think, Your Honor, that The Court of Appeals has generally looked at the overall landscape of the record in cases like this when notice is implicated, and has, based on the landscape of the case, were there enough questions raised, they have remanded for the trial court to make those findings. If there are no further questions from the court, we respectfully request that this court vacate the termination order and remand for further findings by the trial court. Thank you.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court.